Hello, everyone. Welcome to CMC's Dialogue on Mediation. Today we have Mr. Dennis Wilson. Dennis is an arbitrator, mediator, facilitator, and an adjudicator with expertise in international commercial arbitration and cross-border mediation. He is a fellow at CIArb and listed as a mediator and arbitrator with various international dispute resolution centers. He also lectures in the disciplines of mediation and arbitration and is a professor of law at the University of Notre, Australia, and OP Jindal Global University in India. He is also a dear friend of mine. Dennis, it is a pleasure to have you on CMC's Dialogue on Mediation.
Thank you, Siddharth. It's a pleasure for me as well.
Now, Dennis, with the world facing a pandemic, establishments around the globe came to a halt. Various restrictions were imposed by different countries in their own unique manner, which invited inconsistency in the completion of contracts and higher chances of disputes on the horizon. Now, at current, in India particularly, functioning of courts stands limited to matters of national integrity and importance, and commercial or personal disputes have kind of taken a backseat. Now, redressal of such disputes it will take longer than expected, but the economy stops for no one. So now, as India is in unlock one, the businesses are starting to open up while we are preparing to get back to normal and live with the pandemic. Globally, investors and companies have been calling on force majeure and material breach clauses in contracts, and all businesses are encountering similar or various other challenges across the globe. And India has still not been able to flatten the curve, even after a brief 3-month lockdown. Now, particularly this has impacted majorly to the Indian economy. Can you tell us what was your experience of dispute resolution in times of COVID? What is happening in Australia?
Thank you, Siddharth. What is happening in Australia, but may I speak more particularly of New South Wales, is that there was a significant adjustment in the court system. And that adjustment came about by reason of the sheer number of matters that are listed in the court and the filings in the court. As a consequence, hearings have continued, including some hearings in the criminal law where juries are required. But nevertheless, in the civil side of the jurisdictions in this state, the courts have continued, and they have continued remotely. They have experimented with and adopted a particular platform, and that platform has proven successful, and legal practitioners have proven to be very flexible and adaptive. Hearings, therefore, have been organised, and as a consequence, mediation has been continuing and indeed thriving online. It would be true to say that most matters in the civil jurisdiction in this state, whether it be local court, district court, or Supreme Court, go through a form of mediation inevitably. And that inevitability is not because the rules of court demand it, but because it's a good idea. It's a good idea. And therefore, mediation has continued to a significant degree because the court system has continued, and mediation online is proving to be successful. There needs to be some adaptation for mediation online, but that's no reason for saying that there should not be mediation online, because overall the system works.
That's true. And if I'm not wrong, and of course, Australia has been successfully conducting mediations. You also have been, like, since the beginning when I've been talking to you, we are
Yes.
talking about mediations in Australia. Now, mediation seems to be picking up in the Indian system as well. It has always been there at a place, but now it seems to be picking up. Considering the lockdown and everything, now people are also moving towards virtual dispute resolution. For the very first time, Indian courts were, conducting cases virtually. It has picked up. What do you say has been a unique thing that Australia has done in order to promote mediation that you feel that had a lasting impression, and what could India learn from the Australian system?
The aspect of mediation in New South Wales that most comes home to me is that it was tried. It having been tried, it was a slow beginning. I'm going now many years ago, but it was shown to be successful. And as a consequence, mediation is entrenched. It's a part of the culture of the legal system in this state. The unique feature of that is that mediation remains, as it should, a voluntary process. But when you take into account the cost and the time it takes for a piece of litigation, as against the issues that are involved, it takes very little imagination to say mediation must be tried. It adds insignificantly to the cost of litigation. And the chance of success, because it's the parties coming to their own arrangement, are high. And indeed, that's proven to be the case. There are some rules in court where mediation is a process that can be ordered, and indeed, in many instances, it is ordered. But it still doesn't take away from the voluntariness of the process and the voluntariness of the result. The only requirement is of good faith. Those people who come to mediation, those corporations who come to mediation, are required to engage in good faith. And good faith is pretty easy to achieve when you start talking about the issues in the case, in the process of mediation, because people will engage, because there is a good chance, a good opportunity that should not be passed up, in fact, to resolve the matter. So mediation, I think, is entrenched. Online mediation is becoming increasingly popular, partly perforce of the COVID lockdown. But generally speaking, however that process of mediation occurs, whether it's online or whether it's person to person, in my view, it doesn't matter, because it adds to the choices that one has for taking a matter to mediation.
True. But maybe you can share an anecdote or an experience it does seem that the corporates or the companies are a little shy from trying commercial mediation. If you also believe so, then why shouldn't they be? And most of the times, even the law firms or the major corporates, they try to they try to settle the dispute, but before approaching the court, of course. But that is not done by a trained mediator. Now, how does that affect? And also, should major corporates and companies prefer commercial mediation to save cost and time, and of course maintaining the business relations?
Yes. In circumstances where domestic and international trade are growing, CEDR, corporates are more inclined to engage in mediation, not so much in many instances because of a saving of cost and a saving of time, as against the opportunity to maintain a commercial relationship.
Yeah.
And the maintenance of the commercial relationship, the trading relationship, is often of paramount importance. So that, for example, the major telecommunications companies in Australia, I think, generally take the view that if a dispute arises that has to go to court to be resolved, they would consider that a failure, because it's important for that kind of corporation to maintain a commercial relationship with their customers, with their suppliers, with those people with whom they do business. And that reputational factor, that continuation of the commercial relationship, becomes the all-important factor when it comes to many corporations in resolving a matter through competent mediation.
Absolutely. And okay, and now as Australia seeks to strengthen ties with India in key strategic sectors, deals were announced after a virtual summit between both the prime ministers of India and Australia. So, being a noted international mediator, and as now we see the closing ties of India and Australia in terms of relations, businesses, and investments, what do you think should the investors consider in the terms of their dispute resolution clause?
As between Australia and India?
Yeah.
Okay. The factors that weigh on my mind as between Australia and India are all positive. We have the same common law background.
Yeah.
We have extraordinary legal systems. We have extraordinary competence within the legal systems. We have extraordinary trade opportunities. For example, resources.
Yeah.
We have in Australia a very, very significant Indian population. India is comfortable in Australia.
Yeah.
And so, taking all of those factors, there is the most extraordinary opportunity to engage in high levels of trade and high levels of services by way of exchange. One additional factor I should mention is that we have banks and commercial houses of significant reputation. So the transfer of money back and forth can be assured and secured through letters of credit or however payment is to be achieved, so that trade can be seen to be safe and secure. And therefore, the opportunity for exchange between Australia and India is massive. And it would be a great pity if both of our countries didn't take advantage of it. To go along with that, we have methods of resolving our disputes which are able to maintain and continue commercial relationships, and there are many examples of that. And as a consequence, I think that we should come closer together in our endeavours to assure trade, to assure the resolution of disputes which inevitably will arise in trade and commerce and services, but with an overall picture that each country can have confidence in the other of, with integrity and speed, resolving those disputes, and mediation and indeed arbitration contribute to that significantly.
So can mediation be an important tool for future investors in case, any dispute arises?
Crucial. It can be crucial. In the context of this particular aspect of our discussion, CIArb, it would be appropriate to raise the perspective of the Singapore Convention.
Yeah.
The United Nations Convention for the Recognition of Agreements Reached at Mediation.
Yeah.
At this point of time, neither India nor Australia is a party to that convention.
India is.
India is.
India was one of the first signatories to be. And there is a news that, India is in process of coming out with a legislation on mediation.
Yes. The Singapore Convention is going to enter into force later this year, I think September or so, maybe August.
Yeah.
Because it's 6 months after the third party signed on to the convention.
Yeah.
Apart from anything else, the Singapore Convention is going to give mediation for cross-border trade, commerce and services legitimacy. Each country is going to have to bring into force the Singapore Convention as a matter of law, because India, like Australia, is a dualist country, so that the making of a treaty and entering or becoming a signatory to the treaty is only a part of the exercise. You have to adopt it into domestic law and then bring into being the rules by which the mediation agreements are going to be not simply recognised and enforced, but also the rules in relation to the various defences that arise under, I think, Article 5 of the Convention.
Yeah.
That's going to create extraordinary opportunity to ensure that cross-border trade, which inevitably is going to have some dispute because you have trade, commerce, and inevitably there's going to be some level of dispute in some of these contracts. It's going to allow the Singapore Convention to be used for the purpose of not only resolving that dispute, but have the agreement per force of the convention enforced in those countries that become parties to it.
True. Well, can you, second last question, can you tell us what is the domestic scene in major corporates for resolving disputes? Are they considering mediation as a tool?
Yes.
In Southwind?
Yes. And you'll find that in an increasing number of commercial contracts, there are escalating dispute resolution clauses. And mediation becomes an integral part of those contracts. And there's one good reason for it, and that is because if you can avoid spending time, incurring expense, and at the same time maintaining a commercial relationship, then mediation has to be utilized.
Absolutely. Now taking a shift, a small shift on the question. Now you also teach, you're a professor of law. Now being in the legal education field yourself, and also you teach in both Indian and Australian universities. What do you feel is the current status of mediation in the legal curriculum, and what do you think needs to be changed or enhanced for budding lawyers to adopt mediation from a very initial years?
Mediation is not a compulsory subject in many universities, if not most. My own view is that it should be. There are two parts to mediation. One is the process of mediation, and the other is the substance of the mediation. But the subject at university, which is in fact practice and procedure within the court system within which that country operates, and I have no doubt that there's practice and procedure taught in the universities in India.
Yeah.
Practice and procedure is important to have included mediation and arbitration, because they are all legitimate, utilized forms of dispute resolution. And they are not optional.
Yeah.
They are important aspects. So as a matter of process, as a matter of practice and procedure, in my opinion, mediation should be included as core subjects, as a part of practice and procedure in universities. The substance of mediation is another thing altogether.
Yeah. Yeah.
And I have a view that's important to learn those aspects, but nevertheless, that's another subject altogether.
Absolutely. Fair enough. Yeah. One last question then is, what do you think should be the future of dispute resolution? This is a common question that I ask to everyone. Can mediation be the new appropriate dispute resolution mechanism?
It can be appropriate. Yes, it can be a component. People who suggest that mediation is the be-all and the end-all are, I don't think, correct. But it is an important, in fact, crucially important component in the process of resolving a dispute. And there is no downside to using it. So there's no reason at all not to use it. And for persons who are aspiring to be mediators, my only comments are these. Firstly, we've covered the fact that, in my view, mediation should be taught as a compulsory subject, as a matter of process in law schools. Secondly, that would lead more easily to accreditation, because I do believe there should be a system of accreditation of mediators. But so far as the person who is qualified in the process of mediation, and for the person who's become accredited as a mediator, then that person as an individual should concentrate on developing that particular person's unique characteristics as a mediator. It is no good for any person to say, I'm now an accredited mediator and I want to be a mediator like CIArb, or I want to be a mediator like Dennis Wilson, because they'll fail. Because you have your unique characteristics, and I guess I have my own unique characteristics. And unless a mediator in the process of mediation has his own individual characteristics that he or she develops as they should to reflect their personality, then that's a most important aspect of becoming a good mediator.
Very true, absolutely. Thank you so much especially for this last answer of yours. Thank you so much for your time and your insights, Dennis. Really, it was a pleasure speaking to you.
You're most welcome.